Throughout my career, I have witnessed so many positive and negative family wealth and business transitions, far too many to count. What sticks with me the most is the pain and anguish, extreme stress, and unnecessary financial expense clients end up facing when something catastrophic happens and they don't have a safety net in place. Planning ahead can prevent all of this when done right. When my colleagues and I are involved on the front end, preparing powers of attorney, wills, trusts, second home family use agreements, premarital agreements, and postmarital agreements, we help identify hidden risks and potential scenarios that may happen down the road, and we put strategies in place to protect against those risks. An experienced attorney practicing in business and estate planning is best suited to advise families and individuals on legal tools and strategies that will best fit the client's unique needs and circumstances. While there really is no one-size-fits-all approach to estate planning, there are several strategies that we regularly use to benefit our clients. Strategies that help future generations continue to use or share prized family vacation destinations, with or without predetermined exit strategies for those next generation family members who want to opt out. We have strategies that protect family members with special needs, including special needs or supplemental care trusts, to ensure that a ward does not lose essential government benefits. Strategies that thoughtfully transition family wealth to the next generation. Take, for example, a couple with 3 adult children in their 20s, one whom has Down syndrome. This couple owns a home, has investments and retirement accounts, and life insurance totaling $6 million. In this scenario, we need to protect a child with Down syndrome, and we will allocate a third or $2 million to a special needs trust for the benefit of this child. But what about the other 2 20-year-olds? Is distributing $2 million outright to them a wise strategy? I have witnessed the result of this approach, and it is rarely pretty. $2 million handed to a young adult, or even a more mature adult, can be disastrous and a waste of a lifetime of the parent's hard work and savings. One technique we almost always employ is retaining a beneficiary's inheritance in trust until they reach more mature ages. One example is keeping each beneficiary's share in trust until a predetermined age, such as 40, but allowing the child to withdraw a percentage of the inheritance at established intervals, such as 1/3 at age 30, another third at 35, and then the balance at 40. However, the trustee can make distributions for each beneficiary's specific financial needs, such as education, healthcare, a wedding, a business investment, before and in between these ages. Another alternative we frequently employ are lifetime trusts for each beneficiary. Each child's inheritance, not just a special needs child, can be held in trust for them throughout their lifetimes. This strategy protects the beneficiary from freely accessing his or her inheritance until a more appropriate age. It helps protect the assets from third-party claims, particularly a spouse in divorce. And if designed properly, protects the inheritance from the beneficiary's own future estate tax exposure. The beneficiary can also become a co-trustee or a sole trustee of his or her trust at appropriate ages. On the business side of planning, obviously many uncertainties lurk that can foil the best laid plans and enterprises. Business owners will die, or some may suffer unexpected incapacity, short-term or long-term. So I always encourage our clients to have appropriate disability and life insurance in place to protect their family, their business, and their employees. We also encourage clients to have succession strategies in place, such as a buy-sell agreement with a partner or key employees. These plans allow for the continued operation of the business and again protect the business, the owners, their families, partners, and key employees. Unfortunately, in today's world, businesses often suffer from lawsuits, employee theft of company secrets, and unfair competition from employees that are trained on the client's dime. Having appropriate contracts in place, whether with customers, business-to-business arrangements, or employees, are often the best shield and weapon to address these adverse situations. When it's time for a business to be sold, we are often deeply involved with our clients years before but sometimes we are brought in at the tail end just to prepare the sale and transaction documents. Clients that involve us up front, however, often increase their value and their ability to transfer by protecting their intellectual property, having well-structured customer contracts and warranties in place, and restrictive covenants with their key employees that will help ensure that these employees don't wrongfully solicit other employees or customers for at least a certain period of time. So many of the risks and uncertainties families and business owners face today seem so obvious, yet people wait or put it off. Clients who take proactive steps to properly plan for the uncertainties and inevitabilities of life can save substantial money and anguish and pave a smoother road for their loved ones and their business. My colleagues and I are here to help whenever you are ready.